everybody participating today. This will not be new information, of course, to those people who do plan review every single day. But for those of you who aren't in the plan review division, we hope that you find it somewhat interesting anyway, because I do think it is really interesting where NCPC's authorities come from. And in a nutshell, really start with the National Capital Planning Act. And we'll be talking about that a lot today in the context of plan review. We actually, when we did this last year, it referenced fiscal year 2018, and we'll need to update this for 2019. However, the numbers are fairly similar between the 2 years. Approximately, we review a little over 100 submissions a year. That is 92 projects and 12 master plans. Sometimes those master plans are the same ones. They come in more than once for our review, but it's a pretty heavy caseload, I would say, for our plan review division. As you can see here, 70% of the submissions were federal projects and 30% were district projects. And if you look at the next slide, and before I really get into the specific geographic area of NCPC's reach, I can tell you that the majority of the projects we review are in fact located in Washington, D.C., and then the others, of course, are in Maryland, portions of Maryland and Virginia. I will say, though, that the projects that we review in Maryland and Virginia tend to be much larger. These are the master plans for DoD installations. And then, of course, we review individual projects on those installations as well. So Anne is going to tell us a little bit about the National Capital Planning Act now.
Hi, everybody. So as indicated on the slide, the National Capital Planning Act provides the Commission its basic authority. The Act was passed in '52, and it created what is essentially today's Commission. However, there were two earlier versions of the Commission. In the early 1920s, Congress created what was called the National Capital Park Commission, and that was for the purpose of creating a comprehensive park and playground system for the capital. But 2 years later, or a few years later, Congress added comprehensive planning to the Commission's responsibility, and it renamed the agency the National Capital Park and Planning Commission. So as indicated, the Commission has three core functions. The first is preparation and adoption of the comprehensive plan for the national capital, which is the entire geographic region pictured on the slide. As noted, the comprehensive plan consists of two parts. There are federal and district elements. The federal elements are prepared by NCPC staff, and they're adopted by the Commission. These elements apply to federal development throughout the entire national capital region. The district elements of the comprehensive plan are prepared by the Mayor's Office of Planning, and they're adopted by the DC Council following review by our Commission to ensure that the district elements impose no adverse impacts on the federal interest. The district elements are implemented by the District Zoning Commission through adoption of zoning regulations, which are required to be, quote, not inconsistent with the comprehensive plan. So review of plans and projects on federal and district land is the second core function. Generally, plans and projects are reviewed for consistency with the federal elements of the comprehensive plan, as well as best principles and practice of urban planning and design. The third core function is preparation and adoption of a federal capital improvement program, or FCIP. The FCIP evaluates proposed federal capital improvements in the region for recommendation to the Office of Management and Budget. Although the Commission is most often referred to as the central planning agency for the government within the National Capital Region, the Commission also serves as a zoning commission for projects on federal and certain district-owned land within the district. The assignment of zoning authority is basically a function of two constitutional clauses, which result in the legal inability of a local jurisdiction, in this case, the district, to regulate federal land. However, because of the large amount of federal land in the district and the region, and the impact federal land can have on host communities, Congress assigned NCPC zoning authority in the district to ensure compatibility of federal development and to address external impacts of federal development, such as traffic. The district is the only area of the country where the federal government exercises zoning authority. So as indicated, the enabling legislation creating the DC Zoning Commission authorizes NCPC to exercise zoning authority over projects on federal land in the district. The authority was subsequently incorporated into the National Capital Planning Act to ensure a comprehensive list of all of the Commission's authority in one place. When the Commission exercises zoning authority over projects on federal land, it exercises approval authority. In other words, it approves the projects. So the Home Rule Act subsequently extended NCPC's zoning authority to district projects on district land within the central area. Prior to this amendment, zoning authority for the district-owned land had not been conferred on any regulatory agency. The district zoning authority only applies to project on district land within what is termed the central area by the Planning Act. Pursuant to the Act, the central area is a geographic area defined by NCPC and the District Council. It is not a fixed area, and it can change over time if both parties agree and adopt a new definition. As depicted on the map, the current central area is defined as the area encompassed by the downtown Shaw and urban renewal area. I should note that we recently approved the ability to terminate these two urban renewal areas as they no longer were really relevant to what is happening on the ground. Therefore, it's likely that Mike and his folks will ultimately be working with the council and OP to define a new area. However, I should note, as with federal projects on federal land, when the Commission exercises its zoning authority over district projects within the central area, which is currently shown here, or whatever it becomes, it exercises approval authority. The Commission's zoning authority does not extend outside the central area in the district or beyond the district to its environs. However, the Planning Act confers jurisdiction on the Commission to review plans and projects in both of these areas. In both instances, however, the Commission's authority is only advisory.
So, did you know that the Commission plays a role in the zoning of private property in the district to ensure the protection of federal interests? As indicated, the Planning Act authorizes the Commission to review proposed zoning text amendments, map amendments, and planned unit developments. The review is intended to protect any federal interests or interests affected by the proposed zoning action. So I will say that every month we receive referrals from the Zoning Commission in the Plan Review Division. These can largely are either plan unit developments or, changes to zoning via text amendments or map amendments. These usually end up just being small delegated items, meaning, we do like a one-page report on them. We do a fairly high-level overview of the project, and we look to see that there is no impact on the federal interest. And what I mean by federal interest is we're looking to see if there's anything happening to the L'Enfant streets, if there's anything happening to view sheds, if they're violating the Height Act, if the penthouse is correct, that sort of thing. It is rare that we find any problems with these referrals. I will say sometimes there might be something that, it might be across the street from a National Park Service reservation that could cause a problem. Maybe we might voice a concern there, and we return comments back to the Zoning Commission, and they take that into account when they do their final approval of the project. I will also just add that most of the time, we are addressing these issues via the district's larger comprehensive zoning approach. So when the district did their huge overhaul of the zoning code in 2016, I spent a whole year in reviewing the zoning code, making sure that the federal interests are protected. So if anything, I actually think that's probably the more important effort than these little one-off zoning referrals that are done.
I think it's very interesting, and I think it behooves everybody to know a little bit about the commission history. In the 20s and even through this up to about the 60s, NCPC played an active role in acquisition of land for parks, playgrounds, and parkways. Today, this authority is no longer used. It's primarily for purposes, I think, because of budget restrictions. So, and the commission's exercise of land-related authority is largely limited to transfers of jurisdiction. A transfer of jurisdiction does not convey title to the property. It merely transfers administrative control, and the entity receiving the administrative control has responsibility primarily for maintenance. It does not, as I said, transfer title, but only transfers administrative control and management. And this means that party transferring jurisdiction remains the owner, while the party to whom the land is transferred is entitled to use and maintain the party. Sometimes transfers of jurisdiction include limitations on use or other conditions, which, if ignored, can result in a revocation of the transfer. During my tenure with the agency over the past 11 years, I am not aware of any revocation of a transfer. So I think this may not be this again, since this was done in September at the time, the most recent example of a transfer of jurisdiction was in connection with improvements to the Anacostia Community Museum. To facilitate the museum's rehabilitation, the National Park Service transferred jurisdiction over a small piece of land to the Smithsonian, of which the Community Museum is part.
So as many of you know, the foundational document that guides everything we do in plan review is the comprehensive plan. In our reports and in our presentations, we ground our analysis and recommendations in the policies of the federal elements of this plan. As you know, and Mike Sherman as division is always working on continually revising these elements to sort of reflect an evolving region and planning issues. And so when you read our reports, there is actually a specific section that talks about comprehensive plan policies, and staff really does throughout their analysis try to support their recommendations with these policies. Okay, so in addition to the National Capital Planning Act, there are two other very important federal laws that guide NCPC's review of projects, the National Environmental Policy Act and the National Historic Preservation Act. And so this is really important. Every time NCPC has an approval authority, meaning we take a federal action with regard to a project, we must comply with NEPA and Section 106 of the National Historic Preservation Act. So throughout these slides, Anne has mentioned when we have an approval authority or when we have an advisory authority. This is where it really makes a difference. Later in our next brown bag, I will talk a little bit about how the commission treats advisory and approval authority, and I'll share with you right now, there's not really any big difference. They review projects pretty much in the same way. They don't look at a project when they have advisory authority with any less scrutiny. But the big difference here is that when we have approval, we are also doing NEPA and Section 106, which is a whole nother level of analysis and public involvement. I will summarize at the end, again, all those times that we have approval authority versus advisory authority. But before I do that, Anne is going to talk to you a little bit about NEPA.
Thanks, Diane. The National Environmental Policy Act was enacted into law in the late 1969. Its purpose was to ensure that the information on environmental impacts of any federal or federally funded action is available to public officials and citizens before decisions are made and before actions are taken. It's important to understand that NEPA is a procedural requirement. As the courts frequently say in their decisions, NEPA requires an agency to take a hard look at the environmental effects of the project before they make a final decision. And contrary to what many people think about NEPA, NEPA does not mandate a particular income. If the adverse environmental effects of a proposed action are adequately identified and evaluated, The agency is not constrained by NEPA from deciding that other values outweigh the environmental costs. So how does NEPA work? As indicated, NEPA categorizes projects into one of three levels of analysis. At the outset of a NEPA review, a decision must be made as to whether the project qualifies for a categorical exclusion. Categorical exclusions are categories of action that are predetermined based on past experience to not have a significant effect on the environment. If a project qualifies for a categorical exclusion, no further environmental analysis is required.
So I'll jump in here and just say that often for our small projects, we are able to use a categorical exclusion. Some people refer to that as a CADEX, some people say CADEX. And we always note this at the back of the executive director's report. The thing that I find most common sometimes between applicants or when people are talking about NEPA, they'll say things like, oh, you know, we can use a CADEX, so we don't have to do NEPA. And that's totally wrong. You always have to do NEPA if you have an approval or if you're taking a federal action, but applying a categorical exclusion and using a CADEX is doing NEPA.
Mm-hmm.
Okay.
Yep, very good. And I think that's an important distinction. So anyway, if a project isn't eligible for a categorical exclusion, a determination must be made as to whether the project is likely to impose significant impacts on the environment. If the answer is no, or you're not sure, then what is known as an environmental assessment is prepared. An environmental assessment, or EA, examines the significance of the project's environmental effects, as well as reasonable alternatives that achieve an agency's objectives. If the EA concludes with a finding of no significant effect, or what we call a FONSI, then no further environmental analysis is required. If a finding of no significant impact cannot be reached, then an environmental impact statement must be prepared.
So I'll jump in again. In most cases, every time NCPC has a NEPA responsibility, so does the applicant if they're a federal agency. When an applicant prepares an environmental assessment, we participate as a cooperating agency and use the analysis that's done, assuming it's thorough and we feel good about it, to meet our own NEPA responsibility. We don't have to do our own environmental assessment. Also, you may have noticed sometimes that most of our projects don't result in a full-blown environmental impact statement. I think the last project we had an environmental impact statement on may have been the South Mall Master Plan. Now, I will say the problem we do run into, there are two non-federal agencies, I will say, where we end up having to do our own NEPA, which is when the district is doing a project where we have approval authority, which is the district projects in the central area. We usually have to do an environmental assessment ourselves because the district does not have a NEPA responsibility. They're not a federal agency. Also with Capper-Crampton land, and we've actually seen this more lately, and I'll talk a little bit more about Capper-Crampton land in the next brown bag, but essentially this is when the Maryland National Capital Park and Planning Commission undertakes a project on parkland that was purchased with federal funds, but it's now owned by the state. And that's usually when we will also have to do an EA.
So if an EIS is indicated by an EA or at the outset of a project, usually because of the complexity of the project, then an EIS is prepared. An EIS is a detailed analysis of the positive and negative physical and social environmental effects of a proposed action and identified alternatives. The EIS process culminates with the issuance of a record of a decision or a ROD. The ROD states what the decision is, identifies the alternatives considered, including the environmentally preferred alternative, and discusses mitigation plans, including any enforcement and monitoring commitments. The ROD must lay out all factors contemplated in reaching a decision on whether and how to proceed with the proposed action. Further, the ROD must indicate a discussion of all practical means to avoid or minimize environmental harm, whether they have been adopted, and if not, why they were not.
Yeah, and I'll just say, usually we have environmental impact statements for the large memorials, museums, and usually the larger DoD installation master plans also usually do an EIS.
So before we leave NEPA, just a little bit of an update. Many of you may have been aware through press that the Council on Environmental Quality, who is charged with oversight of NEPA, has issued a proposed rule to revise its current regulations. This is somewhat controversial. I'm slowly working my way through them to try to determine what changes, if any, we'll need to make to our regulations. But I think by and large, there's a concern that some of the ability, one real big concern is the ability to analyze the cumulative impacts of a project has been omitted. And some see this as a real effort to gut the heart of the NEPA process. It's anybody's guess where how the proposed rulemaking will proceed or when it will be completed. A lot will be determined, I think, by the outcome of the next election, as well as the CEQ response to the proposed comments received, which I understand were voluminous. So for the meantime, we're going to keep working under our current NEPA regulations, which for those of you, if you want to take a look at them or need them, they are on our project website. So now we're going to turn our attention to the National Historic Preservation Act, Section 106. So Section 106 requires NCPC to consider the effects on historic properties of projects they approve and to afford the Advisory Council on Historic Preservation an opportunity to comment on projects prior to proceeding with the project. Like NEPA, Section 106 review encourages but does not mandate a preservation outcome, and it recognizes that sometimes there is no way for a project to proceed without affecting historic properties. So based on the information gathered through the 106 process, a federal agency may make an informed decision to approve, change, or deny a project. Therefore, the outcome of Section 106 reviews can range from avoidance of impacts on historic properties to acceptance of extensive adverse effects. This Section 106 process is a facilitated engagement process. It includes discussion and consultation of the views of consulting parties, including, among others, the state or tribal historic preservation officer, local governments, applicants seeking an approval of their projects, community groups, and other stakeholders. The Section 106 regulations also require a federal agency to seek and consider the public view at every stage of the review process. The Advisory Council on Historic Preservation may opt to participate in the 106 process and has determined in its regulations the type of projects or undertakings which mandate intervention. For example, these include projects with substantial impacts on important historic projects and controversial projects. Generally, the 106 process involves identification of historic properties, assessment of the effects of a project on historic properties, consideration of alternatives to avoid, minimize, or mitigate any adverse effects, and documentation of the resolution, typically in a memorandum of agreement. The memorandum of agreement commits an agency to carry out the project in accordance with the terms of the agreement and serves as evidence of the agency's compliance with the 106 process. Now, there are also what are known as programmatic agreements versus a memorandum of agreement. And this is usually a high-level look at how the project will be managed, say, as if it involves multiple stages or more kind of discrete projects. So you start at a high level. This is how we'll handle future reviews, and then you'll later do an MOA on for each individual stage of the project.
So I'm going to jump in here with a couple of comments. Most recently, the Advisory Council, if I recall, participated on the Franklin School project and also the South Mall Master Plan, but a lot of the times they do not participate in our projects. The one thing that I do find sort of interesting is that Section 106 and historic preservation obviously looks at both interior and exterior work on buildings. And what's funny, though, is that we only look at exterior work. NCPC's review does not extend to the interior of the building. However, when we have a Section 106 responsibility, it does bring us into the review of the interior work as well. And that is, in fact, what happened with the Franklin School. Even though we don't have any review approval authority over interior work, we ultimately ended up having to review all of that through the 106 process. So just a small comment there. This is actually our little recap and last slide for the set of slides we wanted to go through today. I do want to highlight one more time sort of when NCPC in reviewing projects has a NEPA and Section 106 responsibility. That is going to be for projects on federal land in the District of Columbia. So that's a lot of the Smithsonian and NPS and GSA projects. That's throughout the entire district. District projects in the central area. We have advisory review for all district projects, district libraries, district schools, and all of that outside of the central area. But again, we are only advisory, but we are approval for their projects within the central area. Projects on Capper-Crampton land, that is largely in Maryland. And then master plans, this gets a little more complicated. Master plans, if the applicant does not want to perform an individual NEPA Section 106 analysis on each project to be implemented in the first 5 years of the master plan. Now, coming up at another brown bag, I'm going to talk a little bit more about master plans. But essentially, we give applicants a choice. Again, for example, the South Mall master plan for the group of buildings around the Smithsonian Castle and the Haupt Garden. All of those individual buildings and projects will come in the future, but the Smithsonian opted to do an environmental impact statement for the entire master plan, and therefore they do not have to then do NEPA, assuming the project hasn't changed very much and there aren't any other extenuating circumstances. They will not have to do NEPA on every single project as it comes through because they will have covered it in the EIS that they did for the master plan. I will say NCPC overall, though, only has advisory authority on master plans, if that makes sense. That's throughout the region.
Let me jump in here.
Yeah,
could I just jump in on the master plan issue? I think a good way to look at this is there are master plans and there are master plans. Right. And I say that because generally a master plan is a very high level overview of what the agency wants to do. You do get, in the example of some federal agencies and the Smithsonian, very detailed master plans, which is to say they specifically identify what buildings, where, and specific aspects of the building. So it's really, we're applying both, for those what we call sort of the development plan, we're really applying both our sort of our general master plan and our zoning. So that sort of brings them into a different level, which is why we get involved in NEPA. So I hope I didn't just confuse you.
We will be talking about this more throughout our other upcoming brown bags, but I think I'll stop